Introducing first the plaintiffs, team code LM10. First speaker, Tia Agrawal. Second speaker, Aditi Tiwari. And finally, the researcher, Avika Tyagi. We request our escort, Manan, to guide the participants to the stage. Team code LM10. Introducing the defendants, Speaker 1 of team code LM14, Utkarsh Singh. Speaker 2, Arikta Singh. And finally, the researcher, Ajitya Raj. Ladies and gentlemen, the judges for the finals are, and as I take our name, I request the court team members to escort the judges. Dr. Samreen Hussain, who's an assistant professor at Dr. Ram Manohar Lohia National Law University. Dr. Arpita Kapoor. We welcome you, ma'am. Dr. Arpita Kapoor, who's the founder and general secretary of the NGO Naval Foundation. Mr. Desh Deepak Singh, an experienced advocate with over 15 years of practice in the Supreme Court of India and High Court. Thank you so much, sir. And last but not the least, our advocate Ashutosh Sharma, an experienced advocate with over 15 years of practice in Honorable Supreme Court and High Courts of India. Now, I hand over the proceedings to them. Members of the House, please enjoy the finals of the second edition of La Martiniere Moot Court.
Hello. It's not. Hello. Check. Check.
Trivedi, seated along with Mr. Vincent Clifford, and we will be serving as the timekeepers for today's session. Before we begin, I will introduce you to the participating teams. The plaintiffs shall be represented by LM10, while the defendants are being represented by LM14. Now, with that aside, let's move on to the rules and regulations for this round, which are as follows. Each team will get a total of 30 minutes to present their cases. This time will include rebuttal and sur-rebuttal time. The division of time per speaker is left to the discretion of the team subject with a minimum of 5 minutes per speaker and not more than 20 minutes per speaker. Rebuttals can be assigned a minimum period of not more than 10 minutes. A single bell will be rung at 5-minute, 10-minute, 15-minute and 20-minute mark, whereas a double bell will be rung when the time is over, that is 30 minus the rebuttal time, which depends on the team's decision. If the speaker exceeds the time limit during speech, the exceeded time shall be subtracted from the rebuttal time. A double bell will also be rung at the end of the rebuttal time, and exceeding the time limit will be penalized. The oral argument should be confined to the issues presented in the memorials. The researchers may sit with the speakers during the oral rounds. Now, I would like to call upon the first speaker from the plaintiff side, Tia Agarwal.
30 minutes. 30 minutes. I'll get the bell rung at the 5 and so will you do it? I'll do that. So,
The Council seeks permission to collectively refer to the Honourable Bench as your Lordships. Much obliged. Your Lordships and members of the Court, a very good afternoon. My name is Tia Agrawal from Team Court 10 and I represent the petitioners along with my co-counsel Aditi Tiwari. Counsel 1 will be addressing issues 1 and 2 and my co-counsel Aditi Tiwari will be addressing issues 3 and 4. The case before the Honourable Bench is Tashi and Amber versus Union of Bharatland. May the counsel directly proceed towards the arguments. The first issue before the Honourable Bench is whether the criminal cases charged against Tashi and Amber ought to be quashed. Bharatland is a democratic nation. The laws of Bharatland should provide space for individuals to voice concerns and criticisms against the governmental policies, as this is a fundamental aspect of a democratic society. It must be recognized that healthy political discourse often includes critique and satire directed at governmental policies, and the sedition charges against Tashi and Amber epitomize a grave misapplication of Section 124A, which should be a safeguard for national integrity rather than a tool for silencing dissent. It is respectfully submitted that the charges of sedition against Tashi and Amber should be quashed due to the vagueness inherent in Section 124A. Phrases such as attempts to bring into hatred or contempt and excites or attempts to excite disaffection lend themselves to arbitrary interpretation, and this vagueness has historically led to the misuse of such laws. Having looked at the data furnished by NCRB, that is National Crimes Records Bureau, a total of 399 sedition cases were filed across the country, with many being found to lack merit. Specifically, of the 322 cases filed between 2016 and 2020, 23 cases were identified as false or mistaken in law, and 58 were closed due to insufficient evidence. In 2021 itself, 73 cases were filed with zero conviction. According to a report published by website Article 14, conviction rate was as low as 0.1% between 2010 and 2021. The sedition law, as outlined under Section 124A of Bharatland Penal Code, requires a direct connection between speech and incitement to violence or public disorder for prosecution. Tashi's post, dated January 5th, 2020, articulates his right to express dissatisfaction with governmental actions and to question the treatment of Viranchal citizen. His reference to Emperor's New Clothes effectively critiques governmental neglect and military presence, utilizing satire to highlight disparities between official narratives and actual conditions. Such commentary does not incite violence or public disorder. Similarly, Amber's cartoon dated January
Hello. Mr. Counsel, where is need of violence? Where it is mentioned that the violence is necessary to impose this provision. You are saying, repeatedly saying that the statement concerned is not relating to violence. There is nothing in this section which talks about violence.
It talks about violence.
Your statement, you are saying that you are from the petitioner side.
Yes.
You are saying that the statement made by the Tashi or Amba,
Okay, Tashi or Amba.
yes,
Yes.
there is nothing which is related to violence.
It does not incite violence or public
Yes,
disorder. Yes.
it does not violence. Does not incite violence, but the violence is immaterial. In my opinion, as per the provisions of section 124 capital A, there is no mention of violence. The word violence is not mentioned.
In section 124A, it is mentioned that phrases that attempt.
Please read 124A for a moment. I think it is quoted in your memorial also.
Yes. Your Lordships, Section 124A of Bharatland Penal Code states that whoever by words either spoken or written or by signs or by visible representation or otherwise brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine.
The statement made by the, I think it is Tashi, that teeter thing is written by Tashi or Ambar? Tashi. To the satire made on the teeter, do you not think that this satire will go to the public at large, to other nations also? The citizens of other nations will also read that. And
Well-
it is against the government of the time. It is related to somebody who is ruling this country right now. It is not disrespect to the nation.
Your Lordships, the Constitution of Bharatland provides every citizen to voice their concerns and criticisms under Article 19, freedom to speech and expression.
But there is Article 19, subclause 2 also, no? There is
Yes.
restrictions. I think it is beyond limitation. The limitation provided under 19 to the restrictions there, it is fall under those restrictions. Nobody can make such satire. Do you know what is written on the teeter
Yes.
about clothes and all? It is very disrespectful towards the nation, towards the government of the time, the person who are holding the parliament. You should not say so. How will you defend this satire? Satire should not be there. This can be said in other words also.
Your Lordships, Amber is a caricaturist, so he makes political cartoons that need to include satire. And as far as Tashi's post is concerned, he basically posted a write-up. However, satire was included in Amber's political cartoon, which is a aspect of a political cartoon to bring out satire while showing the realities present in the country or the nation.
Let's proceed with your arguments.
Similarly, Amber's cartoon, published on January 10th, 2020, critiques the continuation of Bharat Land Forces Special Powers Act, that is BFSPA, in a humorous yet poignant manner. Her portrayal of police action raises legitimate concerns about human rights without inciting public disorder. Acts of Tashi and Amber clearly are expressions to their freedom of right to speech and expression are underlined under Article 19. The increasing number of FIRs against journalists, particularly those reporting on government actions, signals an alarming trend towards authoritarianism and a chilling effect on free speech. In the case of Kedarnath Singh versus State of Bihar, the constitutionality of Section 124A was upheld that it explicitly restricted its applications to instances where speech incites violence or public disorder. By interpreting the law too narrowly, a substantial loophole is created whereby expressions that critique government actions such as tashes and numbers, which do not incite disorder, are unjustly exposed to sedition charges. Sanskar Marathe versus State of Maharashtra clarified that mere criticism does not constitute sedition, stating that a citizen has the right to criticize or comment upon the measures undertaken by the government and its functionaries. Vinod Dua versus Union of India further supports the argument that journalists must be free to critique government actions without the threat of sedition charges, and affirmed that a citizen has the right to criticize the government as long as it does not incite disorder. Thus, the legal basis of FIRs against Tashi and Amber is therefore fundamentally flawed. The media serves as a vital check on government actions, and journalists, due to the nature of their work, are particularly vulnerable to prosecution under Section 124A. Their ability to report freely and to fulfill their critical role as the fourth pillar of the democracy is essential for a democratic system. And this is not the first instance where criticism of the government has met with legal repercussions contrary to the freedom of speech and expression.
Counsel, one more question. You are relying on Kedarnath Singh judgment. In Kedarnath Singh, the constitutionality of this section was challenged. We uphold these provisions of section 124A. Why are you challenging it again? If you are relying on the judgment, if you are supporting the judgment, why have you filed this petition again?
Your Lordships, because in the Kedarnath Singh versus State of Bihar, there was a tendency test which was contended, which stated unless and until the speech has the tendency to incite public disorder, that action cannot be constituted as sedition. In the case of Tashi and Amber, there was no incitement of public disorder because the only people who received backlash were Tashi and Amber themselves and not the government. And even after restricting their accounts restricting their accounts, they did not wait for
You may seek a direction from us for effective implementation of the Kedarnath Singh judgment. You may seek so also. But why have you challenged the virus of this law?
Because there is a need to reevaluate Section 124A as it is being used as the aggrandizement of its, as it is being used by the government for the aggrandizement of its own power. Your Lordships, I would like to bring into attention page 15 of the memorial, paragraph 1.4, which highlights various instances of misuse of sedition laws.
So you are saying the Kedarnath Singh judgment is not complete. There are some loopholes, there are some things to be decided.
Yes, Your Lordship.
Okay.
The prosecution bears the burden of proof to demonstrate guilt beyond reasonable doubt, a crucial aspect of criminal law. In the case of Tashi and Amber, the requisites mens rea and actus reus were absent, making the question of reasonable doubt irrelevant. The government's assertion of no reasonable doubt without substantial evidence exploits this legal doctrine to suppress dissent. It is humbly submitted that the quashing of charges against Tashi and Amber would not only uphold their fundamental rights, but also set a critical precedent against the arbitrary and unconstitutional application of sedition laws. The issue 2 before the Honorable Bench is that whether the criminalization of sedition violates Article 14, 19 and 21 of the Bharatland Constitution. Tashi's and Amber's freedom of expression enshrined under Article 19(1)(a) is clearly infringed through Section 124A of BPC. The sedition laws represent a disproportionate infringement on freedom of expression, and the legislation infringing on fundamental freedoms must not only be necessary but proportionate. In Navtej Johar versus Union of India, this Honorable Court revisited the constitutionality of Section 377 of Bharatland Penal Code and declared it unconstitutional even though a previous ruling had reviewed and upheld this provision. The terms employed in Section 124A do not appear in the exceptions outlined in Article 19 Clause 2 of, regarding the restrictions related to freedom of speech and expression. This absence indicates that expressions such as disaffection should be considered unconstitutional, reinforcing the argument that these terms undermine constitutional protection of free speech. The impugned section cannot be included within the exceptions outlined in Article 19 Clause 2 because it lacks a connection to the 8 subjects listed therein. In fact, the impugned section does not even reference any of those subjects. Furthermore, even if we were to assume that Section 124A is linked to one of the subclauses of Article 19, Clause 2, such as public order, it would still be deemed unreasonable. This because this Honorable Court has consistently held that any law restricting speech under the justification of public order must be narrowly framed, establishing a close relationship between speech and incitement of public disorder. Your Lordships, India's obligations under the ICCPR, that is International Convent on Civil and Political Rights, further emphasize the need for stringent standards for restricting freedom of expression. Article 19 of ICCPR protects this freedom as a fundamental right. The term sedition, as employed in Section 124A, is excessively broad and susceptible to misinterpretation, allowing an array of actions to be classified as seditious. Overbreadth means that the legitimate criticism of government actions could be unjustly classified as disloyalty, placing innocent citizens such as Tashi and Amber at risk of prosecution under this law. The vagueness and potential for arbitrary enforcement of Section 124A is thus violative of Article 14, and as established in R. Rajgopal versus State of Tamil Nadu, as Khushbu versus Kanyamal, and Kameshwar Prasad versus State of Bihar, such a broad interpretation could easily encompass protected speech, resulting in a chilling effect, and is violative of Article 14. Your Lordships, even though Article 14 has a clause of reasonable classification, but Section 124A does not fall under its purview because reasonable classification, in a reasonable classification, a law should be just, fair and reasonable, and it cannot be arbitrary, artificial or evasive. Whereas Section 124A is arbitrary due to its vague and ambiguous terminology as stated before. Furthermore, even the punishment cited in Section 124A is disproportionate because on one hand, a person may be charged with imprisonment for 3 years, on the other, that same person may be charged with imprisonment for life, reflecting its disproportionality. Similarly, the use of sedition, which is...
Please come to paragraph number 13 of the Moot problem.
Yes, Your Lordships.
It looks that the social media is also against you. Everybody is criticizing your actions.
That's exactly my point. The people were against Tashi and Amber. There was no incitement of public disorder against the government. So such interpretations...
No, on the contrary, please read paragraph number 13.
Oh, okay.
Paragraph
Yes.
number 13 of the Moot problem.
Amber's cartoon was also flagged with a sensitive content warning on the same day. In the next 7 days, huge masses on social media criticized Amber for calling her called her cartoon as insensitive to national security and secessionist experiences. Many Tings published videos asserting that her remarks could distort the reasoning of necessity behind BFSPA. They commented that in the garb of criticizing BFSPA, she was delegitimizing the government rule.
Yes, the people are saying this. This is not only the government, but the people of this country are also saying on social media that your actions are not at par. You are not acting like a citizen, true citizen of this country.
Your Lordships, the people's alignment with the government shows that there was no public disorder, which...
There is affection in people towards the government. So, there is disaffection in your hearts towards the government, and 124A says if there is disaffection, the provision is attracted.
But there should be an incitement of public order at large, because in the case of Balwant Singh...
Public is disturbed. Your teeter thing is in public notice. Everybody is seeing it. Whatever you have done, there is disruption in the society. They are saying that you are saying something else. You are against the nation. The people, public at large is saying something. There is an opinion. And there is your individual opinion. So what is to be considered?
Your Lordships, everyone's opinions differ according to their histories and contextual differences. However, the freedom to speech and expression is granted to every citizen of the country. And Tashi and Amber, by stating their perspective towards BFSPA and the condition of Viranchal, is basically their opinion, which did not incite public disorder, which is a crucial aspect to charge sedition on someone. Similarly, the use of sedition, which is an archaic remnant of a colonial rule, it has lost its rationale in today's society. With evolving societal norms, Section 124A of BPC also becomes manifestly arbitrary, and this arbitrary nature has long outlived its purpose. This honorable bench, in the case of Joseph Shine versus Union of India, established that a law may be declared unconstitutional if it is found to be highly discriminatory and is not in alignment with societal values. As established in V.J. Roe, the application of sedition has become unreasonable due to significant changes in circumstances over time. In Joseph Shine versus Union of India, it was further contended that the law deserves to be struck down because with the passage of time, Article 14 springs into action and interdicts such law as being manifestly arbitrary. Over time, the court has invalidated various laws that no longer aligns with contemporary constitutional values, rendering it manifestly arbitrary and irrational. The Supreme Court in Shira Bano versus Union of India articulated that a statute may be invalidated for being manifestly arbitrary if it is characterized by capriciousness, irrationality, and lacks adequate guiding principles. The law being excessive and disproportionate leads to unjustified and indiscriminate prosecution and arrest, which also infringe upon right to life and personal liberty outlined under Article 21 of Constitution. The framers of the Constitution recognized that the term sedition was prone to misuse, describing it as doubtful and of varying import. They characterized it as repressive in nature, capable of causing significant suffering, and believed it had no place in an independent India. During discussions about first constitutional amendment, Jawaharlal Nehru referred to the law as obnoxious, indicating that it was unnecessary in a free society. The historical understanding emphasizes the need to re-evaluate the use of sedition laws in today's context, which further enforces the violation of Article 21. The Supreme Court noted in Shreya Singhal versus Union of India that a provision that forces people to self-censor their views for fear of criminal sanctions violates the constitutional guarantee of free speech. This chilling effect stemming from vague laws creates an environment that curtails individuals' liberty and infringes upon their right to life. The Supreme Court has reinterpreted Article 21 in Menka Gandhi versus Union of India and broadened its scope. And this broader interpretation emphasizes the need to protect individuals from arbitrary state actions that violate their freedoms, including the misuse of sedition laws. In State of Bihar versus Lal Krishna Advani, it was stated that right to reputation is an integral part of the right to life and personal liberty outlined in Article 21. This underscores the notion that sedition laws can lead to reputational harm and loss of liberty, thereby violating constitutional protections. The arrest of Tashi and Amber is definitely an attack to the right of reputation. Your Lordships, the conditions under which sedition law was enacted have drastically changed since British colonial era. British laws have done more harm than good, and 77 years post the independence of the country, there is no point in following a law that even UK itself has abolished. Debates in Constituent Assembly and Parliament in 1948 and 1951 reflect the unanimous stance of the framers of the Constitution and political leaders that sedition has no place in independent India. Yet, the law has persisted, and over time it has been weaponized as a tool for reprisals against human rights defenders, journalists, right to information activists, and so on. Even social media posts on platforms like Twitter have triggered action under this law. This outdated law, originally designed to silence Indians under colonial rule by imprisoning freedom movement leaders like Jawaharlal Nehru, Mahatma Gandhi, Bhagat Singh, and so on, has outlived its purpose and is incompatible with modern constitutional morality. It has become manifestly arbitrary, losing its rationale long ago and becoming obsolete in the present day. Your Lordships, in the light of the arguments presented, it is humbly submitted that Section 124A should be declared unconstitutional as it is in violation of fundamental principles outlined in the Golden Triangle, that is Article 14, 19 and 21. My case rests here. Now I would like to call Aditi Tiwari, my co-counsel, to address issues 3 and 4.
मेरे सवाल है कुछ. आपने एक आर्गुमेंट किया था 3 year and lifetime imprisonment, वो आर्गुमेंट क्या था, प्लीज बताएंगे आप?
I stated that sedition, the punishment cited in Section 124A states that either the person would be charged with imprisonment for life or for imprisonment for 3 years or with fine. So this indicates the disproportionality, because if if the crime is not grave enough to charge, to imprison a person for 3 years, then still that person will be imprisoned for 3 years. The gap between the...
Whether it can be seen at the stage of 482 or at the stage of SLP.
What?
Whether can this be seen at the stage of 482 or at the special leave petition. There is a issue of the trial that what is the seriousness of offense you have committed. आपने जो
Doctrine
कंटेंट
of
लिखा है
proportionality.
वो उसका इम्पैक्ट सोसाइटी पे किस तरीके से जा रहा है, इसका वैल्यूएशन एविडेंस की स्टेज पे ट्रायल में हो सकता है. तो हम इस वक्त कैसे कंसीडर करें इस चीज को?
The punishment argument.
3 ईयर की पनिशमेंट उनको मिलनी चाहिए या लाइफ टाइम होनी चाहिए या 10 ईयर होगी या 7 ईयर होगी, वॉट एवर इट इज, दैट विल बी डिसाइडेड बाय द ट्रायल कोर्ट. इन योर मूट प्रॉब्लम आपने हाई कोर्ट में कंप्लेंट को चैलेंज किया कि ये कंप्लेंट हमारे खिलाफ गलत है, ये एफआईआर हमारे खिलाफ, इसको क्वैश कर दिया जाए. दैट डिसमिस्ड बाय द हाई कोर्ट. आप एसएलपी में हाई कोर्ट के ऑर्डर को लेके आ गए, ठीक. अब आपका आर्गुमेंट ये है कि ये सेक्शन इसलिए गलत है क्योंकि ये एग्जैक्ट ईयर ऑफ पनिशमेंट डिसाइड नहीं कर रहा, ये 3 साल भी बोल रहा है या लाइफ टाइम भी बोल रहा है.
Sir, your lordships, that is just one of the factors indicating its disproportionality. There are various ambiguous terms.
ये तो सारे पनिशमेंट्स में होता है
No, sir.
कि नॉट मोर देन 10 ईयर्स और लेस देन 7 ईयर, या लेस देन 7 ईयर में 4 ईयर की पनिशमेंट हो सकती है, 7 ईयर की भी हो सकती है, या अप टू 7 ईयर्स होती है, या अप टू लाइफ टाइम होती है, या अप टू 10 ईयर्स होती है.
Your lordships, the punishment state up to. However, section 124A does not cite up to. It just states either it's 3 years or life imprisonment.
3 ईयर और लाइफ इम्प्रिजमेंट.
Yes.
ग्रेविटी ऑफ द ऑफेंस, मेरा सवाल फिर वही है कि ग्रेविटी ऑफ द ऑफेंस क्या स्पेशल लीव पिटीशन में देखा जा सकता है कि नहीं?
Yes.
You said that sedition is an old law, right? Now, considering the geographical status of India, bordered by neighboring states and countries, if we do away with this law, how do you think we can safeguard India as a state integrity and unity of India?
Your lordships, there are various alternative terror legislations which are much more well defined, like UAPA, that protect the state's integrity and security.
And by surrendering or doing away with this law on sedition, do you think we'll be completely surrendering to the demands of every citizen?
Pardon?
If we do away with laws like sedition and we keep intact or we give importance to fundamental rights that you people are claiming are being infringed through the law of sedition, there's an arbitrary action of the state as contended by you.
Yes.
So does that mean the state should surrender to the demands of every citizen?
They should not surrender to the demands of every citizen because the state's integrity is above the fundamental rights. However, in the case of Tashi and Amber,
That's why sedition laws are there, because the state's integrity is of utmost importance.
however, it is pretty vague and ambiguous and is irrelevant in contemporary India due to the inter-terror legislations already present. In the Kedarnath Singh versus State of Bihar, there were no alternative legislations which protected state's integrity and security. However,
But states, this particular state is more prone because of its geographical situation. So things need to be more cautious on these states as compared to other. Don't you think so?
Your lordships, even though Viranchal Pradesh is a volatile region due to the political and social challenges, sedition allows aggrandizement of the government's power because, as mentioned in page 15 of the memorial, the government has misused the sedition laws several times because it allows area of interpretations and is arbitrary in nature because of that.
State has utilized it arbitrarily, or certain group of citizens are using it as a context to portray the state in the wrong position? Is the state using it, or people like Tashi, when their fundamental rights are curbed or sedition laws are imposed on them, are they trying to defame the government?
They are not trying to, Your Lordship, they are not trying to defame the government. They are merely criticizing the government's action because the government cannot be equated with the state. In a democratic nation like Bharatland, which is the largest democracy, every citizen has the right to criticize and put forward their opinion and perspective without inciting public disorder. In their case, public disorder was not even disrupted because the government interpreted that potential disorder might exist. However, if we go by this virtue, the government will arrest everyone by stating that potential disorder might be incited.
In that case, preventive detention is also wrong.
Preventive detention is much more well defined than section
Continue.
124A. Your Lordships, my case.
Was one question only. You are saying that we cannot equate the state with the government. Both cannot be equated.
The
But-
terms should be replaced.
Yes. But the government is the only visible representation of the state. How can you see the state? How can you say that the state is working? Government is the only visible representation, visible symbol you may say.
However, Your Lordships, if we state government in a particular section that a citizen cannot go against the government, that almost seems as if people don't have the right to criticize or even state their opinion, which is pretty similar to what happened in colonial era. Many dissenting voices were silenced by the colonial government. So, that is.
Thank you so much.
Your Lordships, my case rests here. Now I would like to call my co-counsel Aditi Tiwari to address
Yes,
issues
please.
3 and 4.
Your Lordships and members of the court, my name is Aditi Tiwari and I shall be representing the petitioners as their co-counsel. I shall be dealing with the issues 3 and 4. The counsel seeks permission from the Honorable Bench to proceed with the arguments. The third issue before the Honorable Bench is whether the existing safeguards and mechanisms under the BITA address the grievances of the petitioners adequately. The petitioner submits that the BITA, while intended to regulate the digital space, fails to sufficiently safeguard the constitutional right to freedom of speech and expression under Article 19(1)(a) of the Constitution. Furthermore, the Act lacks necessary adjudicatory mechanisms, promotes self-censorship by private entities, does not provide adequate measures to regulate dominant social media platforms, and is vulnerable to abuse by such platforms, thereby undermining the rule of law. To be more articulate, we as petitioners have divided the third issue into various sub-issues, them being whether the BITA provides sufficient safeguards for the protection of free speech and expression, whether the BITA lacks adequate safeguards and adjudicating mechanisms, enabling misuse of private social media entities, whether the BITA fosters a culture of self-censorship by private bodies, violating free speech, whether the BITA lacks necessary measures to regulate social media platforms effectively, whether the BITA can be subject to abuse by large social media companies running afoul of the rule of law. Addressing the first sub-issue, Your Lordships, the BITA, particularly through the Section 66A and 69A, allows the government and the intermediaries to regulate online speech. We contend that these provisions lack sufficient procedural safeguards, violating constitutional principles. Section 69A of the BITA, which empowers the government to block online content, does not ensure that the affected individuals are given prior notice or an opportunity to be heard before their content is removed. This undermines procedural fairness and the principles of natural justice. Section 66A of the BITA, due to its vagueness and chilling effect on free speech, was struck down by the Supreme Court in the case of Shreya Singhal versus Union of India. Similarly, the blocking provisions under Section 69A, although not struck down, continue to lack transparency and procedural safeguards, which inhibit free speech. As stated by my co-counsel, restriction on internet access has to be in terms of Article 19(2) of the Constitution of Bharatland, that is in keeping with the test of proportionality. In the case of Anuradha Bhasin versus Union of India, the Honorable Court held that any restriction on internet access would have to be in terms of Article 19, subclause 2 of the Constitution of India, that is in keeping with the test of proportionality. The court accordingly held that Section 69A of the Act could not be used for a complete shutdown in an area unless necessary and unavoidable. It was also held that such orders could not be for an indefinite period. The test of proportionality has been applied in other cases as well to prevent misuse of the provision, including in the Teeter case, which takes a deep dive into the various requirements and principles to be applied in the cases relating to Section 69. Clearly, the BITA does not adequately safeguard the right to free speech as required by the Constitution. Its vague provisions and lack of procedural fairness leads to arbitrary restrictions on speech. The second issue, whether the BITA lacks adequate safeguards and adjudicating mechanisms enabling misuse by private social media entities. Taking into consideration the experiences of Amber and Tashi, where the content was published over social media and it was further removed and their Twitter accounts were restricted, Section 79 of the BITA provides immunity to the intermediaries from liability for third-party content, provided they comply with government orders for content removal. However, this immunity lacks the necessary adjudicatory oversight, leaving room for arbitrary or inconsistent enforcement by social media platforms. Recent instances of content takedowns based on vague acquisitions of offensive and controversial content, even when such content does not violate any specific laws, illustrate the lack of checks and balances in the Act, which definitely leads to an arbitrary exercise of power by social media entities. A very recent and relevant case here is the Kisan Mazdoor Sangharsh Committee versus State of Punjab, which raised concerns about freedom of expression and the overreach of Section 79 of the BITA. The BITA's lack of adjudicatory mechanisms results in the misuse of power by social media companies, leading to unjustified censorship that violates users' fundamental rights. Addressing the third sub-issue, Section 79 insensitivizes social media platforms to over-regulate content in a bid to avoid legal disputes or penalties. As a result, intermediaries take down content even when it falls within permissible speech. This chilling effect on speech curtails freedom, as individuals and platforms are forced to regulate themselves far more stringently than required by the law. Recent content moderation practices of large platforms show a tendency to take down user-generated content without clear justification, especially in cases involving politically or socially sensitive topics. This overreaction is driven by the fear of legal consequences under the BITA, leading to self-censorship that stifles free speech. The fourth sub-issue, the BITA provides limited mechanisms to regulate the functioning of social media platforms despite their significant influence on public discourse. Section 79 grants them the immunity as intermediaries, but there is no comprehensive regulatory framework governing their operations or for ensuring that they adhere to the constitutional standards of free speech.
Just a minute. Question. You claim that the criminal proceedings are initiated with ulterior motives to harass your clients. Okay? You claim that the government is functioning to harass you with ulterior motives. My question is, why the government is harassing you? Why are you so special? There are so many people criticizing government. There are so many people in Viranchal Pradesh only which do not like this laws, 124A, they are against these laws or the special act also. But why you? Tashi Amber, what's so special in them?
Your Lordships, first of all, Tashi and Amber both are journalists, and the reach that they have over social media platforms like Twitter, and also when they state something on social media platforms and in the modern world where...
In a way, you are saying that the government is attempting or is taking down the media.
No, Your Lordships, that's not my exact statement. The exact statement is that the government knows the reach of journalists, and moreover, in such a sensitive state like Viranchal, when Tashi and Amber bring out the reality of the government and also the reach that they have over, as I told, over the social media and the world where, in the modern world where the social media is radicalized so much, and people tend to believe in journalists more easily when they state something as compared to normal citizens.
Is it duty of a journalist to take sides? If they are journalists, they should write something in support of the Special Act and the police and the military also. They are just taking one side. They are against the government. Is it a duty of a journalist? Journalist should be balanced. The approach should be balanced.
Your Lordships, I agree the journalists should be balanced on both the sides, but moreover, before being journalists, they are also the citizens of the country, and they are merely stating their opinions. And under Article 19, they have the right to free speech, and so they can state their opinions without the fear.
Let us proceed further.
Okay.
I just have one small question. You talk about that, yes, I can state my opinions, but those opinions should bear something to reality, right? Your opinions should have a reflection of realities. If that is not reality, isn't it again spreading of fake information? And then there need to be the provisions where they could be handled actually.
Your Lordship, Amber and Tashi are trying to bring out the reality of the government. How is it misusing these provisions like BFSPA in these volatile regions? May I proceed? The fourth, okay. This also happened with Amber and Tashi as their content was suppressed and arbitrarily removed. This was held by the court in the case of Rakesh Vaishnav versus Union of India and others, which is what happened with Amber and Tashi as their content was suppressed and arbitrarily removed. The fifth and the last sub-issue, whether the BITA can be subject to abuse by large social media companies running afoul of the rule of law. The rule of law mandates that no entity, whether private or public, should be above the law, and all actions must be subject to judicial oversight and accountability. The BITA, however, leaves room for large social media platforms to exercise unchecked discretion in moderating speech, often without any legal or regulatory oversight. Without strict regulatory frameworks, these platforms can make arbitrary decisions about content, often infringing on users' rights without facing any legal consequences. In the numerous instances, social media platforms have been accused of biased moderation practices, removing content that challenges dominant narratives while promoting certain viewpoints. The absence of clear checks and balances under the BITA allows these companies to operate in violation of the rule of law. BITA not only lacks adequate provisions to safeguard the right to freedom of speech and expression, but also leads to misuse by dominant social media platforms such as Twitter. Arbitrary censorship, self-censorship by intermediaries limits free expression, lacks necessary measures to regulate social media platforms effectively, leaving space for dominant players to act without adequate oversight, violating the rule of law. The fourth issue before the honorable bench is whether the actions of the government in India implementing the BITA, BFSPA and the sedition laws are unreasonable due to their vagueness.
Before you start your fourth issue,
Yes.
one example I am giving to you. आपके आर्गुमेंट्स में कई बार ये आ चुका है, पहले भी आया था, कि बहुत से ऐसे केसेस होते हैं जिसमें आप ये कहते हैं कि उसमें एक्विटल हो जाता है, कन्विक्शन नहीं होता. उसका एग्जाम्पल लेकर के आप ये कहना चाहते हैं कि ऐसे केसेस में भी एक्विटल हो जाएगा. आपका यही डिफेंस है ना? ये डिफेंस है कि नहीं है?
We are firstly asking for quashing of the sedition charges, which is impractical with the aspect that there was only the potential to misuse and so there was disproportionality between the action that was taken by the government and the potential harm that was meant to the sovereignty, integrity and the public order of the country.
In your third issue, you have written sufficient procedural safeguards. What are they?
In context.
क्या होने चाहिए? मेरा सवाल ये है. आपने ये तो कहा कि बीटा में सेफगार्ड्स नहीं हैं. आप ये कह रहे हो, वो कौन से ऐसे सेफगार्ड्स हैं जो हो जिससे ये चीज फुल प्रूफ हो जाए कि हाँ ठीक है, ये एक्ट सही है?
Your Lordship, first of all, in the section 79, section 79, it gives the exemption to the intermediaries to regulate their platforms but there is no regulatory oversight by the government. So that is what we are asking for, that there should be proper regulatory oversight by the government as well.
So you are asking for the regulatory authorities for that, na only? Ma'am, you want to ask something, please.
Taking forward your argument, taking forward the sir argument, you have mentioned a lot of time that how this law might have been misused or this has been misused by the government. But not for once you have said that those statements, and that's your words, that the law says incitement of violence. Now a person of a little high stature, a journalist, using a statement like that, the statement as if want to compromise on personal. Isn't it threatening the lives of security personals a threat enough to constitute sedition?
Your Lordship, it was a mere opinion and expression that was made by Tashi. It was not backed up by any facts, and it was a mere expression under the free speech, the fundamental right of free speech that he has under the Constitution.
Okay.
See, very simple it is. जर्नलिस्ट का रोल क्या होता है? मैं बहुत ही सिंपल शब्दों में पूछता हूँ. What is the role of the journalist or a journalism? Is that to speak the words of the society. ठीक? उनका काम यही है ना कि जनता की आवाज को आगे लेके आना. ये होना चाहिए. Para 10 of the Moot problem. Last line. I too ask today to the Prime Minister / Emperor, is this a public voice or it is a personal voice of that journalist?
Even though he is a journalist, but he, as a citizen of the country, he is
writing in the capacity of citizen or writing in the capacity of journalist?
He's writing, he has stated I, so he is merely stating a personal opinion.
That means he is writing his personal opinion, na? That he is not doing his job as a journalist. That means he is against the government, he is biased against the government, he tried to defame the government.
Your Lordship, it's just a mere opinion that was stated by him, and he has...
In newspaper, you are a petitioner counsel. Please explain कि एक जर्नलिस्ट कैसे अपनी व्यक्तिगत चीज को किसी भी पब्लिक एट लार्ज की बता के लिख सकता है और वो खुद कह रहा है कि ये मैं हूं, मैं ये पूछ रहा हूं. और ऐसे में वो नेशनल...
And take it forward, if he is writing in his capacity, then the standards which are applicable to journalists, the privileges which are applicable to journalists are not applicable to him then. Then the cases which you have cited with respect of that is a journalistic freedom, that freedom is not available to him anymore, because then he is talking about his personal ideals, then he is discussing his personal morale, right?
Exactly.
Your Lordship, but it is contempt that he led to incitement to public disorder. If he is writing in as an individual, then how can the government state that it is leading to public disorder and the reach of the reach that he has as a journalist?
यही मेरा सवाल था आपसे कि अगर वो पर्सनल कैपेसिटी में लिख रहे थे, अगर उन्होंने ये पर्सनल कैपेसिटी में लिखा है, तो उनका ग्राउंड दूसरा होना चाहिए कि दैट आई हैव रिटन इन माय पर्सनल कैपेसिटी। ये आपका ग्राउंड ही नहीं है कहीं पर पूरी केस में, आपने ये ग्राउंड कहीं नहीं लिया हुआ है। आप एज एन जर्नलिस्ट उसको प्रेजेंट कर रही हैं। आपने बार बार कहा कि ही इज़ अ जर्नलिस्ट, ही इज़ राइटिंग ऑन बिहाफ ऑफ जर्नलिस्ट, फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन की बात आपने करी है, फ्रीडम ऑफ प्रेस की बात करी है आपने, आप उसकी बात कर रही हैं। आपका ग्राउंड कहीं पर भी ये नहीं है कि ये उनके अपने व्यक्तिगत विचार हैं जो वो लिख रहे हैं। एज एन जर्नलिस्ट हम नहीं लिख रहे।
And one more thing, please see 5th line, paragraph 10. I wonder if our government has any intention whatsoever treating us as our state could be cut off from the rest of the Bharat land through a highway blockade. What are you suggesting? To block a highway?
Your Lordship,
Whatever capacity you are writing, nobody can write on a social platform to block a highway. What is this?
Your Lordship, he firstly mentioned the word wonder, so it's just a mere criticism and personal opinion.
No, use a word wonder will not make your suggestion dilute. Anyways, proceed further with your argument.
The fourth issue before the honorable bench is whether the actions of the government of Bharatland in implementing BITA, BFSPA and the sedition laws are unreasonable due to their vagueness and potential misuse and arbitrariness leading to infringement of the fundamental rights of the citizens of Bharatland. The petitioner respectfully submits that all these laws have been misused against dissenting voices, creating an environment of fear and self-censorship, ultimately undermining democracy. The BITA has been widely criticized for enabling arbitrary removal of user-generated content by social media platforms without clear guidelines, leading to potential abuses of power and violations of free speech. The BITA has very vague definitions for harmful content. The terms harmful and unlawful are not clearly defined, leading to inconsistent application. In the case of Binod Singh versus State of Bihar, it was emphasized that the vagueness in these laws can lead to misuse and wrongful prosecutions. Tashi and Amber's arrest is clearly a result of this vague and poorly defined law. It is the duty of the state to protect citizens from the arbitrary actions taken by such social media platforms. Section 79 clearly lacks effective mechanisms to protect users from the arbitrary actions. This indicates the need for accountability and fair processes in content moderation. Content being removed without due process raises concerns about user rights. This was highlighted by the Honorable Bench in the 2016 case of Sushil Kumar Sharma versus Union of India and in the case of Puttaswamy versus Union of India. The emphasis was laid on transparency being equally applied to content moderation under the BITA as well. The government in applying BFSPA in many instances has exercised arbitrary powers by granting sweeping powers to security forces, leading to significant human rights abuses without adequate accountability mechanisms. This broad discretion given to the security forces of Bharatland often leads to human rights violation. This can be seen in cases like Nandini Sundar versus State of Chhattisgarh and Extrajudicial Execution Victims Families Association versus Union of India, which clearly creates a culture of impunity with no accountability or actions taken. Various reports from human rights organizations have urged reforms to prevent the misuse of BFSPA in conflict zones. In the incident reports documented numerous civilian killings attributed to security forces operating under BFSPA, raising alarms about unaccountable actions. Lack of accountability mechanisms, BFSPA lacks robust mechanisms for holding security personnel accountable for their actions. The case of People's Union for Civil Liberties versus Union of India emphasized the need for judicial oversight in cases involving state action. This honorable court has found and again condemned the use of excessive force, emphasizing that such actions violate fundamental rights. The sedition charges imposed on Tashi and Amber are clearly on arbitrary grounds and unreasonable, and they are done by the government only to prevent its dark reality from being exposed out to the common people, as the petitioners' posts were not an attempt to aggravate people against the political party, but rather were a step towards reality. The sedition laws not only suppress dissent, but pose a significant threat to the fundamental right of freedom of speech and expression.
Counsel, there is a question. The Kedarnath Singh judgment is related to state of Bihar. Here we are talking about a state which has so much geopolitical tensions. There are border disputes also. How can the judgment of Kedarnath Singh be applied in this situation?
Your Lordship, may I take time to refer my counsel? Your Lordship, the Kedarnath Singh, in the Kedarnath Singh judgment, the tendency test and the incitement of violence test was given, which is applicable to
But where is the discussion about these special states? These 8 states are something different from the state of Bihar. The situation is entirely different. The special act is here. There is no special act in the state of Bihar. There is need of that act. Okay? There is you have the mood problem. So many words are written about the geopolitical tensions. I think Kedarnath Singh judgment is totally distinguishable in this present case.
Your Lordship, even in the mood problem, it's mentioned that Viranchal is also moving towards normalcy as of now.
Moving towards, therefore, there is a need of stringent laws for forward moving, for speedy development.
But there's also a need to loosen the strict laws because they are moving towards normalcy.
All these developments are because of these laws. Otherwise, the people will protest. There is all protest all over the state. How will state function? These laws are there for the development only. The government has enacted these laws for controlling the situation over there. You have breached that law. Now,
The cases like Kedarnath Singh versus State of Bihar and R versus Governor of Delhi criticized the lack of clarity in the law, emphasizing the need to protect the legitimate dissent. And also, just because a particular state is has certain geopolitical conditions does not mean that the people in the state cannot voice their opinions and their ideologies.
I think you should say that therefore there is a violation of Article 14. There must be equal protection of law and there must be equality before law. There could not be any discrimination. Okay, let's proceed further.
The laws must be clear to avoid misuse and arbitrary enforcement. Individuals must be free to express their opinions without fear of retribution. There is definitely a need of scrutiny and checks against the arbitrary enforcement of the sedition laws. If permitted, can we please proceed towards the prayer? In the light of the arguments, we as petitioners respectfully pray that this honorable court be pleased to quash the criminal charges of sedition against Tashi and Amber, declare section 124A of the Bharatland Penal Code 1860 unconstitutional for violating articles 14, 19 and 21 of the Bharatland Constitution, suggest the Union of Bharatland to review and amend the rules under BITA to ensure adequate safeguards for freedom of speech and transparency in social media regulations, passed such other orders as this honorable court may deem fit and proper in the interest of justice. The case rests here.
The council seeks permission to address the bench collectively as your lordships. If your lordships are well versed with the facts of the case, the council seeks permission to proceed to the issues. A very good afternoon, your lordships. My name is Utkarsh Singh. I'm the standing counsel for the side respondents. We'll be arguing 4 issues before this honorable court today. First, that the appeal filed by the petitioners in this honorable Supreme Court is not maintainable. Second, that the criminal cases filed against Tashi and Amber on the charges of sedition should not be quashed. The other 2 issues will be covered by my co-counsel, them being that the criminalization of sedition does not violate Article 14, 19 and 21 of the Constitution of Bharatland. And the last one being that there are adequate safeguards and mechanisms within BITA and or in any rules or regulations made in exercise of the powers granted under it to address the grievances of the petitioners. If your lordships are well satisfied, the council seeks permission to proceed with the first issue. Your lordships, it's humbly submitted before this honorable Supreme Court that the petitioner has absolutely no locus standi to approach the honorable court because the following case does not involve any substantial question of law, your lordships, and even in the remotest manner or way there has been absolutely no grave miscarriage of justice. If your lordships would be kind enough to refer to page 12 of the memorandum on behalf of the respondents, your lordships, in Ganga Kumar Srivastava versus the state of Bihar, this honorable Supreme Court held that the Supreme Court will not interfere with the concurrent findings of the court below unless of course the findings have been vitiated by errors of law or there is a gross miscarriage of justice, both of which your lordships is largely absent in the present case because the High Court has been exceptionally thorough throughout its judgment while dismissing the petition which has been filed by the petitioners. If your lordships would again be kind enough to refer to paragraph 2, wherein this honorable Supreme Court has observed in Preetham Singh versus State that the discretion granted to this, that the discretionary power that this honorable Supreme Court holds under Article 136 of the Constitution of Bharatland is to be exercised in exceptional cases, whereby your lordships, again, the 2 requisites come into place. First, that there is grave miscarriage of justice, and second, that there is a substantial question of law, both of which your lordships is largely absent in this instantaneous case, and thus it is not maintainable. I'll be delving more into both these requisites as I proceed with this issue. Proceeding to sub-issue 2.1, your lordships. Proceeding. Your lordships, in the present matter, the Honorable High Court has rightfully come to the decision to dismiss the petition for quashing of the FIR directed towards the petitioners. Your lordships, the petitioners have been convicted justly for the crime committed, and there has been absolutely, again, no miscarriage of justice. Your lordships, in Kedarnath versus the state of Bihar, this honorable court held that the freedom to express has to be guided. If your lordships would be kind enough to refer to paragraph 2 of page 13 of the memorandum, that freedom has to be guarded against becoming a license for
Mr. Counsel,
vilification.
there is one question.
Your lordships.
Do you know whether this 124A is cognizable or non-cognizable offence?
Your lordships, is a cognizable offence.
During British era, it was cognizable or non-cognizable?
Your lordships, the offence of sedition was made cognizable during the 1975 emergency.
1975.
Your lordships.
Why? In British era, that was non-cognizable. When an offence is non-cognizable, for investigation, there is a need of magistrate's order.
Your lordships.
That was sufficient safeguard for imposition of this provision. Now, your police inspector is registering cases under 124 capital A.
Your Lordships, this decision has largely come into place due to the premise of the
Is your police inspector has enough knowledge to register FIR under 124 capital A? Do you think he understands the provision? And the Kedarnath Singh's judgment particularly.
Your Lordships, again, the point here remains that one does not have to wait for the actual incitement of violence to happen for any form of expression to qualify as sedition. The mere tendency that any expression or any form of article or write-up will lead to sedition, Your Lordships, is sufficient to qualify as the offence of sedition. Again, Your Lordship, the principle here which we need to take into consideration is the principle of foreseeability. Your Lordships, if it happens to be completely foreseeable that any form of expression will lead to sedition, which Your Lordships is completely foreseeable in the present case, I'll be delving more into that when I argue further.
Okay.
Your Lordships. Your Lordships, Mr. Tashi's write-up ends with a suggestive notion of a highway blockade in the orderly borderline state of Viranchal. Your Lordships, this very evidently showcases an attempt to create public disorder and also fuel separatist tendencies because Mr. Tashi, Your Lordships, happens to be a journalist who has been largely active in the state of Viranchal for the past 10 to 15 years and is very well versed with the political and societal state of the state. Your Lordships, it's also very pertinent to note that the state has been continuously marred with separatist tendencies for a prolonged time period of 15 years, which is why, Your Lordship, the BFSP has been implemented in the said state. So, Your Lordship, for Mr. Tashi to exercise the considerable influence that he holds to express his public opinion, which, Your Lordships, is largely and absolutely not backed by facts, but is only supplemented by misinformation, following a suggestive notion to suggest that the already borderline state of Viranchal, a state which already has separatist tendencies, can be cut off from the rest of the nation through a highway blockade. Your Lordships, is again a very deliberate attempt at inciting violence and threatening the very national integrity of the nation of Bharatland.
What is the difference between fair criticism and sedition?
Your Lordships, again, fair criticism happens to be taking place when there happens to be, again, Your Lordships, I would like to very clearly clarify, since you have given me this opportunity, to clarify side respondent stand. Your Lordships, criticism is absolutely important for democracy. We completely agree. Criticism happens to be the hallmark of democracy. Without criticism and dissent, there will be absolutely no overall growth or maintenance of the healthy institution of democracy. But Your Lordships, as again laid down in the Kedarnath judgment, when this criticism goes beyond the purview of criticism, goes beyond the purview of Article 19 and happens to also possess a direct call or a direct threat to incitement of violence or creation of public disorder, or in any way or manner falls within the purview of Article 19 subclause 2, that is the reasonable restrictions which are implied on the article of which are applied on the right to freedom of speech and expression, then Your Lordship, it qualifies as sedition. Because Your Lordships, again, the key principle that we need to take into consideration here is that yes, criticism, while does happen to be completely criticism does happen to be very important for democracy, Your Lordships, but when this criticism is not backed by facts, even if it is backed by facts but possesses a call for violence, a call for a threat to national integrity, or a call for in any way or manner disrupting public order, then it qualifies as sedition, Your Lordships. If Your Lordships are well satisfied, the Council seeks permission to proceed. If Your Lordships would be kind enough to turn your attention to page 13, subclause 2, last paragraph of the memorandum, that there is absolutely it is most humbly submitted before this honorable court that the present case does not involve any substantial question of law. Your Lordships, in Abraham Mallory Dilitray, the honorable, it was observed that the Privy Council will not review criminal proceedings unless it is shown by a disregard of the forms of legal processes or some violation of the principles of natural justice, which Your Lordships is largely absent in the present case. Your Lordships, it's pertinent to note that this particular case, the case of Abraham Mallory Dilitray, has been used by this, has been referred to by this honorable case, by this honorable court on multiple occasions when this court has debated upon the discretionary power which falls within the Article 136 of the Constitution of Bharatland. Your Lordship, the requisites for sedition have again already been specified in this Kedarnath Singh versus the State of Bihar judgment, and sedition's constitutionality has already been upheld multiple times by judicial precedent with respect to the duties of the central government by virtue of Article 355 of the Constitution of Bharatland to protect the state from separatist tendencies which have already been prevailing in the state of Viranchal for a prolonged period of time Your Lordships, it's also pertinent to note that the state is also marred by external conflict and the threat of external conflict with the neighboring nation Yuan. Thereby, Your Lordships, the BFSP has been implemented in the state for a time period of 15 years. Your Lordships, side petitioners have argued before this court that there happen to be absolutely no accountability mechanisms under the BFSPA. But Your Lordships, I will also be countering that point when we cover the second issue. Your Lordships, it's also very pertinent to note that in the Shri Chunnilal case, the Honorable Court held that a question of law is not a substantial question of law when the question was practically covered in a judgment of the highest court, and if the general principles which are to be applied in this particular question of law or in this particular case have already been decided by the Honorable Court, which Your Lordships has already been done in the Kedarnath judgment. Your Lordship, the Honorable Court also held that the question will not constitute a substantial question of law if the only question was applying those general principles which have already been established to particular facts of the case. So, Your Lordship, this does not qualify as a substantial question of law. There is absolutely no grave miscarriage of justice, and thereby the petition filed by the petitioners before this Honorable Court is not maintainable. If Your Lordships are well satisfied, the Council seeks permission to proceed to the second issue. Your Lordships, it's humbly submitted before the Honorable Court that the criminal cases filed against Tashi and Amber on the charges of sedition should not be quashed. Your Lordships, if you would turn your kind attention to paragraph 2 of page 15 of the submission on behalf of the petitioner, on behalf of the respondents. Your Lordships, in Common Cause and Another versus the Union of India, this Honorable Court held that for classification as a seditious act, the act should either lead to direct incitement of violence or have the tendency or the intention to create public disorder, both of which Your Lordships is largely present in this following expression.
Mr. Counsel, give me, please enlighten me, where is the element of violence? Give me that sentence which is related to violence. Tashi made a statement, you are saying that there is an element of violence. Therefore, you have imposed 124 capital.
Your Lordships, if you would be kind enough to refer to the Moot problem, Your Lordships, 1 second. Point number 11, Your Lordships.
Yes, I am here.
Your Lordships, point number 11, second last line, if you do not want to compromise on personnel, start treating us like humans. This, Your Lordships, in the general purview can very well be inferred.
Inciting violence. I am talking about inciting violence, where the accused have been charged with the 124A. Therefore, they must have been incited violence in public.
Your Lordships.
They are encouraging public to take arms or anything against the government. Is there anything there?
Your Lordship, it's pertinent to note that the call for violence does not need to be absolutely direct. Your Lordships, when someone says that if you do not want...
Where is the remote chance? Where is anything over? There is nothing. Violence is invisible.
Your Lordships, but when we take a look at the line with regard to the context...
Yes, I'm looking.
Your Lordships, please note that firstly, the illustration starts by saying that you come up with a decision to continue BFSPA and call yourself proportional. Your Lordships, this again is exciting disaffection towards the government, which falls well within...
May be correct. But where is violence? Then the hypocrisy reaches new heights every day. If you want us citizens to care about you and like you, these practices have to be given up. What is the difference between a cattle life and that of ours under this rule? If you don't want to compromise on personnel, start treating us like humans.
Your Lordships, again, when you direct a comment that you don't want to compromise on personnel to a CRPF official, Your Lordships, that can very well be inferred as a call for violence. And even if Your Lordships, if this Honorable Court does not infer that as a call for violence, Your Lordships, if you would be kind enough to refer to Article 19, Subclause 2, whereby the Constitution of Bharatland talks about the reasonable restrictions. Your Lordships, a point of contention in reasonable restrictions also happens to be a threat to national integrity. Your Lordship, national integrity is very well threatened when Mr. Tashi in his write-up suggests that the state of Viranchal can be cut off from the rest of the nation through a highway blockade. Your Lordships, it is also pertinent to note that these statements have been made in a state and have been directed to a state which has been already marred by external conflict, a state which already has instances of separatist tendencies, a state which has already experienced volatile conditions as it was laid down by the petitioners as well, Your Lordships, while pleading their case. Your Lordships, it can very well be inferred that if you say this comment to a citizen of Viranchal who happens to be directly influenced by all of such circumstances, and if this comment is made by Mr. Tashi or Ms. Amber, who happen to be people of great influence, then your lordships, it can very well satisfy the condition for a call for violence or at least advocacy for violence.
Thank you. Now conclude your arguments.
Your lordships. If your lordships are well satisfied, the council seeks permission to go. If your lordships would be kind enough to turn your attention to page 15, last paragraph, in Pankaj Bhutalia versus the Central Board of Film Certification and others, this honorable court held emphasis on the importance of context of expression while categorizing it as seditious. Your lordships, when Ms. Tashi and Ms. Amber's expression is viewed with the full context in which it was made, it falls well within the boundaries, and it satisfies and it meets all ingredients of the offense of sedition. Your lordships, before we delve into that, your lordships, it was stated by side petitioners while pleading their case that your lordships, Mr. Tashi and Ms. Amber are people of great influence. Your lordship, the exact line stated by them was, in today's world, day and world, these people hold great importance and great influence on social media platforms. They also happen to use the word radicalization, your lordships. So your lordships, when they themselves can claim that Ms. Tashi and Ms. Amber can be people who happen to have great influence and can also be very well capable to incite radicalization, then your lordships, if now you would turn your kind attention to the exact statement which have been made by Mr. Tashi enlisted in point 10 of the Moot problem, whereby your lordship, Mr. Tashi starts by saying, years and years of neglect and carelessness have emptied our states. Your lordships, this line also happens to be supplemented by misinformation, primarily because your lordship, the Bharatiya Nagarik Party, which happens to form the central government in the nation of Viranchal, also happens to form the state government in the state of also happens to form the state government in the state of Viranchal. So it can very well be assumed that the Bharatiya Nagarik Party also happens to have the mandate of the people, your lordships. So for Mr. Tashi to start by saying that years and years of neglect and carelessness have emptied our states happens to be a bizarre claim. He goes on to say, your lordships, on top of it, we are met with brutal state action and military abuse by the central government. Your lordships, while it is true that the AFSP has been implemented in the state for a prolonged period of 15 years, your lordships, it's absolutely not true that there are not enough adequate accountability mechanisms. I will also be delving into that when we proceed with the argument, your lordships. So this claim also happens to be false. Then, your lordships, Mr. Tashi goes on to delegitimize the very image of the Prime Minister of the nation, who not only happens to be a representative of the state government and the central administration, who, your lordships, is pertinent to note are exercising sovereignty on behalf of the state, but your lordships, he also happens to be a representative of the Prime Minister's office. Your lordships, after saying that, spreading the misinformation that there has been years and years of neglect, after spreading the misinformation that the state is met with brutal state repression, and also going on to delegitimize the image of the Prime Minister, he goes on to say that I wonder if our state can be cut off from the rest of the nation through a highway blockade. Your lordship, this is a well-crafted message to amount to this last suggestion, which can very well have the tendency, in all plausibility, have the tendency to lead to incitement of violence, in all plausibility have the tendency to lead to separatist action.
Isn't the standing council going too far when saying, I wonder? I can wonder a lot of things. I can wonder right now if an earthquake comes.
Precisely, Your Lordship.
Precisely. So precisely, if on my wondering, are you going to prosecute people that too under a law which directly affects their liberty and life? Because I wonder something.
Precisely, Your Lordships. As a matter of fact, I completely agree with you. Wondering absolutely is not an offense, Your Lordships. But, Your Lordships, when you advocate that wondering on a platform which happens to be a significant social media intermediary, on a platform which has millions and millions of users, on a platform, Your Lordships, where you hold significant and paramount influence, and then, Your Lordships, you go on to state that wondrous comment while also supplementing it with delegitimization of the image of the central government, while also supplementing it with misinformation, then, Your Lordships, it does not fall within the purview of simple wondering. Your Lordships, I can wonder that there happens to be state repression in the state of Viranchal, but, Your Lordships, if I am a journalist who has millions and millions of followers on a social media platform, if I am a journalist who, as stated by side petitioner, can very well radicalize the people of a state, and then, Your Lordships, I go on to make this suggestive notion that the state can be cut off from the rest of the nation through a highway blockade, then, Your Lordships, that wondering is absolutely...
But there is a contradiction what you are saying and what the Moot problem is saying. because according to the Moot problem, the public was against him. So the public would not have, so how does you say they incite the violence? The public whom you say he could have influenced was actually against him. So that means even though he might wanted to,
Your Lordships.
you don't have that kind of influence. The public never agreed with him, so it could not be sedition charges. The public is very clear, is against his notion, so there is no foreseeability of violence, as you say.
Again, Your Lordships, the important point, we again delve into the requisites for sedition. Your Lordships, for sedition, the offense of sedition to occur and for any expression to be accounted in the under the offense of sedition, Your Lordships, there does not need to be actual happening of violence. Your Lordships, again referring to the Kedarnath judgment, if the expression has the mere tendency to incite violence, Your Lordships, if there has been a reasonable attempt made at inciting violence, Your Lordships, then it very well falls within the purview of sedition. Your Lordships, I believe it's the respondents, as a matter of fact, argue that the actual happening of the offense is only relevant when it has actually happened. But Your Lordships, it is not, it is absolutely not within the purview of Article 19 if this court exempts someone giving the reasoning that the actual incident of violence had not happened, ignoring the fact that a considerable attempt was still made to incite violence in the public. If Your Lordships are well satisfied, the council seeks permission to proceed. Your Lordships, summarizing my issue really quickly, if Your Lordships would be kind enough to refer to page 16 of the memorandum, whereby I'll be talking about the illustration of Miss Amber, this petitioner number 2 as well. Your Lordship, Miss Amber's illustration also follows the same premise. The following comment constituting illustration interrogates that you come up with a decision to continue BFSPA and call yourselves proportional. This, Your Lordship, is again filled with an opinion that is absolutely not backed by facts, but only by misinformation, because Your Lordship, if you would be kind enough to refer to, again, paragraph number 3 on page number 16 of the submission of the respondents, in Naga People's Movement of Human Rights versus the Union of India, this honorable court held that post the implementation of the BFSPA, there shall be periodic review of the declaration of the BFSPA every 6 months, which is to be undertaken by the governor. Your Lordships, please note that the governor happens to be a person who very well understands the societal and political scenario of the state and also the central government. So, Lordships, for the petition, for Ms. Amber to argue and state that there has been an attempt that the BFSPA has been continued in the state and then she questions the proportionality of the government is absolutely false, Your Lordships, primarily because this requisite is even mentioned in the very bare act of the AFSPA. Secondly, Your Lordships, in Hirendu Gogoi versus the Union of India, this honorable court also held that if the army takes any citizen into custody under the BFSPA, he is to be handed over to the SHO of the nearby police station within 24 hours. Your Lordship, so the question of armed repression to a large extent is largely unlikely. Secondly, Your Lordship, if the BFSPA is implemented in the state, it happens to be due to the certain reasoning that there are already separatist tendencies present in the state, and that does not ipso facto mean that the armed forces is misusing the parts of the BFSPA. So, Your Lordship, for Ms. Amber to assert that the BFSPA's implementation is irproportional is again firstly inciting disaffection towards the government and also the army, which happens to be an institution of this nation. And Your Lordship, then it also follows a direct threat to the army by stating that if you do not want to compromise on a loss of personnel. If Your Lordships would be kind enough to refer to page 17 of the memorandum, in Mbala versus France, the European Court of Human Rights held that one could not take the claim or the right to express idea and opinions through satire because the overall context of the performance demonstrates hatred, which Your Lordships is right, which Your Lordships is absolutely done in Ms. Tashi's case. Lastly, Your Lordships, if you turn your kind attention to page 18 of the submission of the petition of the respondents, it is argued before this honorable court that there has been no infringement of the right to freedom of speech and expression. Your Lordships, if you would be kind enough to refer to paragraph 3, according to Article 19 of the International Convention on on Civil and Political Rights, 1996, the freedom of speech may be subjected to restrictions provided they are prescribed by law and are necessary for respecting the right and reputations of others. Your Lordships, Article 19, subclause 2 of the Constitution of Bharatland follows the same premise whereby there are reasonable restrictions which are imposed on the right to freedom of speech and expression when the overall rights and overall welfare of the nation is given more importance over the right of a certain citizen. Your Lordships, in Gompers versus Buck Stephen Range Co., if you would be kind enough to refer to the last paragraph, Your Lordships, it was held that in the name of freedom of speech and expression, the protection is not extended to those who utter words that may have the ill effect of force, Your Lordships, which is again very well plausible in the petitioner's illustration and comment. Second, Your Lordships, again, side petitioner as a matter of fact have reiterated this point by stating that the illustration and the write-up which has been published by the petitioners happen to possess mere opinion and expression, not backed by facts. This was the exact line which has been stated by Madam Co-Counsel for side petitioners. Your Lordship, they also happen to state that they misquoted the offence of sedition, saying that potential disorder cannot allow one to be convicted under the offence of sedition, whereas, Your Lordships, the exact requisite for the offence of sedition is not the aspect of potential disorder, but the tendency to incite sedition, Your Lordships, under which one can be very well convicted under section 124A of the BPC, which is why, Your Lordships, Amber and Tashi have been rightfully convicted and the FIR against them ought not to be quashed. Your Lordships, again, this is lastly to conclude that the comments which have been made against the Prime Minister, delegitimizing the very image of the Prime Minister, also happen to be supplementing this cause or call for incitement of violence, thereby the FIR.
Mr. Counsel, what do you mean by Prime Minister? If somebody criticizing Prime Minister, how can you put sedition?
Certainly, Your Lordships, had that criticism
An
only been...
insult to the Prime Minister, how can an insult to the Prime Minister be a sedition case?
Certainly, Your Lordships, again,
number
please
one
understand.
and number two, have you read explanation 2 of section 124 capital A? Explanation 2. And
Your
tell me
Lordships,
how the case of Amber and Tashi does not fall under this explanation.
apologies, Your Lordship, could you please repeat?
How the case of Amber and Tashi
Your Lordships.
do not fall under this explanation, because this explanation is an
Constitution.
exception. IPC
Lordships.
124 capital A.
Your Lordships. Your Lordships, explanation 1.
2.
Your Lordships. Comments expressing disposition and measure for good view to obtain. Your Lordships, again.
This is my second question.
Your Lordships.
First, answer the first query. How an insult to the Prime Minister is sedition?
Certainly, Your Lordships. Your Lordships, again, I would like to reiterate the point that had that expression only been limited to the criticism of the Prime Minister, it would absolutely not fall within the purview of sedition. But, Your Lordships, please understand that the line which is delegitimizing and criticizing the Prime Minister is not the exact line which incites sedition, Your Lordships. It just happens to be supplementing the claim of the suggestive notion of the cutting off of the nation through a highway blockade. So, Lordships, again, please understand that the expression which has been made by Mr. Tashi is very well crafted. Firstly, Your Lordships, he spreads misinformation stating that the BNP does not have the public's mandate, which, Your Lordships, it very clearly does. Secondly, Your Lordships, he delegitimizes the claim of the authority of the Prime Minister, which is completely fair, Your Lordships. I agree that scrutiny of the Prime Minister does not fall within the purview of sedition. Thirdly, Your Lordships, he again goes on to say, unreasonably claim that the implementation of the BFSPA is, again, Your Lordships, unreasonable, which it absolutely is not. And then, Your Lordships, he goes on to say that I wonder if the state could be cut off from the rest of the nation through a highway blockade. Your Lordships, these first three lines, without the last line, to some extent, can also be categorized as criticism. But, Your Lordships...
Now answer my second query. Second one.
Certainly, Your Lordships. Your Lordships, again, this explanation also follows the same premise. Your Lordships, disprobation, disaffection towards the government.
What is disprobation? What do you understand with this word? Disapprobation.
Your Lordships, I believe disapprobation is motivating the public opinion to some extent.
No, give me just one synonym of this word. Disapprobation.
Disapproval, Your Lordships.
Yes, disapproval. Now read it. Comments expressing, let us say, disapproval. Okay.
Your Lordships.
Comments expressing disapproval of the measures of the government with a view to obtain their alteration by lawful means,
Your Lordships.
without exciting or attempting to excite hatred, contempt or disaffection, do
Your
not
Lordships.
constitute an offence under this section. I think their case is relating to this explanation only, because they do not approve of your special act.
Your Lordships.
They are facing trouble.
Your Lordships.
They are not saying that law is correct. They can say this. They are saying in some other, because they are journalists, they know how to write. they like satire, they use satire.
Your Lordships.
So what is wrong in that?
Again, Your Lordships, to answer your question, Your Lordships, I would also like to bring in the aspect of intent, Your Lordships. Had the intent of the petitioner been to actually achieve constitutional reform, Your Lordships, he would have very well filed a petition or a case in the relevant courts of jurisdiction, Your Lordships. But for the petitioner to firstly, Your Lordships, again, the problem here, Your Lordships, remains same. Had that petitioner's attempt been to excite disprobation towards the government, completely fine. Had the petitioner's intent been, or the petitioner's expression in any way or manner, had sought constitutional reform, Your Lordships, completely fine. But Your Lordships, that is not what is happening in this current expression. Your Lordships, the petitioner is not only inciting disprobation towards the government, which is completely fine. This disprobation is not backed by any form of facts or manner, in any way or manner whatsoever, Your Lordships. Second, Your Lordships, the petitioner is expressing his personal opinion. He, Your Lordships, in no way or manner is an elective representative of the people expressing the people's opinion. He's expressing his own personal opinion. He's not advocating for constitutional reforms in any way or manner. And Your Lordships, lastly and most importantly, Mr. Amber is calling for, Miss Amber is calling for a threat for loss of personnel towards the CRPF, and Mr. Tashi is calling for a highway blockade. So, Your Lordships, this does not even possess, this possesses very well the intent to qualify sedition, and Your Lordships, the expression also possesses tangible sentences to qualify sedition. If Your Lordships are well satisfied, the council seeks permission to allow my co-counsel to argue the further two issues. Much obliged, Your Lordships. Constitution.
The council seeks permission to address the third issue, that is criminalization of sedition does not violate Article 14, 19 and 21 of the Constitution of Bharatland. Your Lordship, Article 14 is a cornerstone of our democratic edifice and is a firm guarantee against any sort of arbitrariness, which has been reaffirmed by the Honorable Supreme Court in various cases like that of Maneka Gandhi versus Union of India and E.P. Roepa versus the state of Tamil
I
Nadu.
request you to keep it very precise, just putting forth your arguments.
Certainly, Your Lordship. The doctrine of reasonable classification is a careful analysis against sedition law, which has been faced scrutiny, which has previously as well faced scrutiny under Article 14. The doctrine of reasonable classification, as articulated in the case of Anwar Ali Sarkar versus State of West Bengal, and again reiterated in the case of Ram Krishna Dalmia versus Justice S.R. Tendolkar, allows for distinction between different categories of individuals or situations, provided these distinctions are based off two bases, that is intelligible differentia and have a rational nexus or a rational connection to the object sought to be achieved by the policy. In this case, in the case of sedition particularly, that is section 124A, the Supreme Court in the case of Kedarnath Singh versus State of Bihar upheld its constitutionality, finding that it creates a distinct and clearly defined category of actions constituting sedition. The application of sedition in Viranchal Pradesh is particularly relevant given our case due to the region's geopolitical history. As the Supreme Court also recognized in the case of Ramesh Thapar versus State of Madras, the state has the power to impose any reasonable restrictions on freedom of speech for public order and scrutiny if it deems fit. The Supreme Court's interpretation of section 124A, that is sedition law in Shreya Singhal versus Union of India, further clarified its scope. The court distinguished between advocacy and incitement, emphasizing that the section applies only to actions that have a tendency to incite violence or any sort of public disorder. The interpretation again aligns with the test of proportionality, which was established in the case of Justice K.S. Puttaswamy versus Union of India, that is the judgment of 2017, which upholds the three-pronged test, where they test for a legitimate goal, the need for that particular restriction, and a balance. Moreover, section 124A does not violate Article 14, as it uniformly applies to all individuals regardless of their status or background. The law's reasonable relation to its objective, that is the security, integrity and unity of their state, is particularly evident in the sensitive border situation present in Viranchal Pradesh. As the Honorable Supreme Court recognized in Superintendence and Remembrance of Legal Affairs versus Corporation of Calcutta, special provisions may be necessary in special circumstances, and taking into consideration the Viranchal Pradesh's complex security situation, these legal measures are justified. Lastly, the classification of Section 124A is totally reasonable, its application is totally non-arbitrary, and its objectives are legitimate and necessary, particularly in the regions facing complex security challenges like that of Viranchal Pradesh. Moving to my second sub-issue under this issue, that is the violation of Article 19. The Supreme Court in the landmark case of Kedarnath Singh versus State of Bihar upheld the validity of Section 124A as well, affirming that it does serve the legitimate state interest of public order and security. The court clarified that the provision becomes operative only when the words have the tendency to create disorder or disturbance of public peace by any sort of resort to violence. The threefold test, which was again reiterated in the case of Modern Dental College versus State of Madhya Pradesh, requires that the restriction must have a proper cause, the measures taken must be rationally connected to the fulfillment of that person, and lastly, there should be no less restrictive alternative available. Section 124A, that is sedition law, very easily satisfies all of these criteria. In the context of Viranchal Pradesh, where border tensions with Wuhan persist and security concerns remain paramount, the restriction serves the proper purpose of maintaining sovereignty and public order. Moreover, the proportionality doctrine, as we had elaborated earlier as well, requires that restrictions on fundamental rights must be proportionate to the legitimate aim pursued. The 76% decline in any sort of extremist incidents in Viranchal Pradesh demonstrates that Section 124A's application has been proportionate and effective. Moving to Article 21, the Supreme Court in the landmark judgment of Maneka Gandhi versus Union of India consistently held that any restriction on personal liberty has to be fair, just and reasonable. Section 124A easily satisfies this requirement through its efficient procedural safeguards. The law is clearly defined and has been further fine-tuned through various judicial precedents, which serve an essential national security interest while employing means to proportionate to its very own objectives. The procedure established by law requirement under Article 21 of the Bharatland Constitution, as was articulated in the case of, as was interpreted in the case of A.K. Gopalan versus State of Madras, and then reiterated in the case of Mohammad Arif versus the Supreme Court, demands again that the procedure needs to be fair, just and reasonable. This framework governing sedition cases, including the requirement of sanction for prosecution and the availability of bail, satisfies these criteria. The Supreme Court also, in the case of Common Cause versus Union of India, emphasized that authorities must strictly follow these guidelines before registering any cases under Section 124A. The Supreme Court, again in the case of Romila Thapar versus Union of India in the judgment of 2018, emphasized that dissent is the safety valve of any democracy. It is also, however, it also recognized that when dissent crosses into incitement or threatens the national security or regional security, particularly in sensitive regions, the state has the legitimate power to impose reasonable restrictions through fair legal procedures if it feels the legitimate need to. Furthermore, the Council seeks permission to proceed with the last issue. That is, there are adequate safeguard mechanisms within the Bharatland Information Technology Act or in any rules or regulations made in exercise of powers granted under it to address against the grievances of the petitioners. Point number one being the framework in the Bharatland Information Technology Act provides a robust procedural safeguard to protect user rights. While prior notice may not be mandated in all cases, this approach is justified for prompt action against harmful content as recognized by the Honorable Court in Shah Singhal versus Union of India. If your Lordship would turn to page 25 of the memorandum presented before you.
There is no need to read all this, but just one answer.
Yes, sir.
Is there any authority before which a person can go and ask for redressal of his grievance? A private citizen. Is there any authority or not?
Yes, Your Lordship. this framework also provides for grievance officers, which again offer.
Is there any application of mind by the grievance officer in this case against Tashi number?
No,
No.
no, Your Lordship.
You accept this?
Yes.
Okay, thank you so much.
Do I have the
There is no
permission?
need to conclude those arguments. We are satisfied. We are
All
satisfied.
right. Continuing,
We continue with the prayer clause.
directly to the prayer.
Directly to the prayer clause.
All right, Your Lordship. I request to proceed with the prayer. In light of the issues raised, the arguments advanced, and the facts of the case, the counsel for the respondents humbly pray before the honorable court to a judge and declare that the appeal filed is not maintainable, that the criminal cases filed against Tashi and Amber ought not to be quashed, that the criminalization of sedition does not violate Article 14, 19 or 21 of the Bharatland Constitution and thus shall remain as an offence under the Bharatland Penal Code, that is the one established in 1860. And lastly, that there are adequate safeguard and mechanisms within the Bharatland Information Technology Act or in any regulations made in exercise of powers granted under it to address the grievance of the petitioners, and to further pass any other order that the Honorable Court may deem fit, and for this kindness, the Council, on behalf of the respondent, as duty bound, shall forever pray.
Thank you everyone present here. Now, with the permission of the Honorable Justice, I would like to conclude the final session of the Martiniere Moot Court 2024. The judges may rise and be escorted to the side hall or the dining hall by the escorts present here. The participants may remain seated until the judges are escorted. Thank you.
Ladies and gentlemen, boys and girls, I hope you enjoyed that scintillating round of arguments. We will break for 15 minutes right now, and following that we shall have the prize distribution right here at Spence Hall. So you have a break for 15 minutes, go out, have a cup of tea or what you would prefer, and do come back in 15 minutes so that we can begin with the closing ceremony. Thank you.